We're going to be talking about enforcement. This is really one of my favorite things. I'm a longtime community association attorney, and I think I'm a board member. I've been doing it for so long, and I just love that. I love the hearings because of a couple reasons. They are really result-oriented. You can really get stuff done at hearings if you get it done right. So what we're going to do is I'm going to take us through the enforcement process. It seems kind of mysterious to a lot of board members. We're going to take all that mystery out of it. We're going to then show what your role is or could be. So you can really then feel comfortable at a board hearing or just knowing that the board hearings are happening. And then sprinkled through it all, we're going to have some tips and tricks. So basically, we want to sort of give a framework to our discussion today. If you have a question or a comment, just raise your hand. We're a small group, so let's take advantage of that. You want to have something to say, then go ahead and say it, or a question. You don't have to worry about it because we don't have a whole lot of people here. So the idea is, what's the framework? So you have issues in every association has an issue in your community. I like to say that 10% of your association members, I don't care what association it is, 10% shouldn't be living there for various reasons, right? I know you agree. All right, noise, cars, speeding. Did I hear someone say unruly tenants? Unruly tenants. So yes, we talked earlier. All right, so this is sort of a framework right here. Come back here. This is one that was really common. It really was. Guess what? It still is. All right, so this is where you have an adult child who is living in a community. The parents own it, right? So the parents are going to be 70 years old or above. The child is going to be 30, 40, 50 years old, the child. And the owners expect you, board members, to babysit their child. And oftentimes, the child has issues. Drugs, a lot of it is PTSD from being in one of the wars, whatever. They then do things like break into walls, harass fellow residents, turn water on indiscriminately in the common area, cut wires electrically, all kinds of things. So how about you guys? Anyone have any burning issues at your community? There's perfect community. Okay, well, if you think of one, to chime in. All right, because if you don't, you will. All right, so the question is, does the board have a duty to act? Now, how do you know when you have a duty to act? So you have the CC&Rs and the rules, right? And so going back to this, do you have a CC&R provision of sellers and users of illegal drugs frequently stay at the son's home? Does your association have a CC&R provision that says that? No, it's not going to say that. No CC&Rs say that. But almost every single set of CC&Rs says no noxious or offensive activity, right? That's the catch-all, right? If you have issues like this that are like sort of nebulous, that's the provision in your CC&Rs. If someone's speeding, you probably have a rule that says no speeding or excessive noise or what have you. So you have that catch-all. How about this one? The adult son wanders through the community. I get that as a complaint. Board members, managers come to me and say, this resident, this tenant is walking through the community and he's intimidating us. Well, how is he intimidating you? He's intimidating us because of how he looks or what he's saying. So this one, I put this one in here. because that's probably not going to be enforceable, right? It has to be something in addition to that. What are you going to do? Have a rule that says no one can wander through the community and intimidating people? No, not likely. One that I have right now is the police frequently visit the home. And so I think that's offensive misconduct. So what are we going to do? What are we going to do with our issues? Let's take the mystery out of it. So first, all right, we talked about a CC&R or rule has been violated. A question for you guys. If you have a CC&R provision and you don't enforce it, what do you think's going to happen in the long run? Hint, in the long run, when you want to enforce it again. But nothing? Sort of. It's going to get worse. Okay. What I'm driving at you guys is if you don't enforce a CC&R provision and you try and enforce it later, then the courts are going to say, well, you waived your right. So there's this community down in Palm Springs, and they had no dogs in the condo. No dogs in the condo CC&R provision. And so for years, they didn't enforce it. Everyone had their little Palm Springs dogs in their condos. And so what the court said is, you waived your right. How are you going to prevent anyone if you've never done it in the past? How are you going to go to this owner now if you haven't done it in the past? So you could waive your rights. Side note, because a lot of associations go through waves, right? Tough enforcing this board. Next years come along. Now no one's enforcing tough. So what you can do is you can reinvigorate your enforcement by adopting rules, then basically taking some steps. So it's not completely impossible, but you want to be careful, because if you don't enforce it, then you're not going to be able to enforce it later. All right, so how about adopting rules? So this is my favorite. This is really a way to solve problems at your community. If you have a provision, if you don't have a particular rule about what someone's doing, and it's, for instance, let's say it is, how about, it's a condominium complex and there's skateboarding in the common area. It's dangerous. It shouldn't be there. You can't be skateboarding in the streets. It's causing accidents. It could be dangerous to the people who are skateboarding, right? And so what you can do is you can adopt a rule. Anyone here go through the rule adoption process? The rule adoption process. What you can do is you can adopt particular rules about specific types of potential violations by sending out the proposed rule a month before a board meeting where you can adopt it. There's a process in place that allows you to adopt rules, sort of gap filling or between the cracks in your CC&Rs, things of that nature. So you can actually do it.
If it's a rule, it doesn't have to go out to the entire membership, right? It's just the board?
So if it's a rule, she's asking, it doesn't need to be approved by all the owners. Ding, absolutely. That is the beauty of it. Rules are adopted by boards. CC&R provisions have to be passed by the owners. So you need like 51% plus if you want to go ahead and make a CC&R change. However, if it's a rule, the board can do it. Exactly. Let's before we leave this slide, we have our skateboarders. So we want a rule. So what do you think about this rule? No children can ride skateboards in the common area. Coming back to you. You can't say children. Great job. You can't say children. No persons may ride skateboards. You can't discriminate against children. I wasn't discriminating against children. It's just completely obvious. It doesn't matter. The law is very sensitive on this nature. Any of you have to deal with the Civil Rights Department, formerly the Department of Fair Employment and Housing of the state of California, with respect to any, you guys have living blessed lives. No war stories here. Everyone's just living great. I love it. So it's really easy for residents, tenants, owners to make discrimination claims against associations. Super easy. All right, so we want to be really careful about that. All right, when we are enforcing, what is our overriding goal? Is it to compel compliance, not punishment, not collecting fines? Yes. Okay, so if you don't like someone in your community, you don't get on the board and go and impose fines on them. So it's not a money-making scheme either. It's just to compel compliance. Why is it, what are some reasons why compelling compliance? Why is compliance with the CC&Rs a good thing in your association? What are some good things that it will do for your association if you compel compliance?
Well, maintain safety is one thing.
Maintain safety, excellent.
Emphasize that another thing is to stay within budget and be fiscally responsible.
Exactly.
Because insurance.
There you go.
These days.
It's you guys, it is. It's all connected. It really is. Your property values, right? Your how you spend your time as a board member. You don't want to be spending your time dealing with compliance because you haven't taken enforcement steps. You want to be able to have nice and consistent enforcement. Then you have a nice community. It looks good. The property values are high. The insurance rates are as low as they can be. All right, so we have this violator. So what are we going to do? We're going to go ahead and try a courtesy letter or a violation notice, whatever you want to call it, right? You like that one. Please. Okay, so what if probably, it used to be hard, but it's easier now, and that is getting written statements from owners about who complain about another owner or tenants. It's easier now because of email, right? So it's pretty easy to shoot an email off to the manager. As board members, you could see different issues of non-compliance. It might be, do we know what the difference between, say, an architectural violation and a maintenance violation and a misconduct violation are? Do we know what those? So someone could be doing things architecturally on their home, on the exterior, without getting approval. Maintenance, not taking care of what they're supposed to take care of, whether it be a fence or their exterior or what have you. And then misconduct, that's just being noisy, et cetera. So we want to be able to handle those and describe those in the violation notice. And you want to put in some good ingredients, give them a deadline to cure. You want to say what the provision in the CC&Rs and the rules is that they're in violation of. And then you want to let them know that they'll be punished. So discipline will come if, in fact, they don't comply. Sending out the courtesy/violation letter that handles all those owners who really just made a mistake, didn't know, the good people made a mistake, one-timers, right? The tough ones are what comes up, like our example. That's when you want to have a hearing. So this is where you can solve the tough ones. So you have, like I said, 10% in almost every association, they shouldn't live there. These owners shouldn't live there. Some of them are there just to make your lives miserable, right? Some, they just don't understand. Third, they're just trying to take advantage of the system. So these are the tough ones. Anyone wants a copy of this presentation, feel free to take photos, but you could just, I'll give you one. And so now that we get into the hearing, we have what's called due process, right? You can't take away rights in America without giving them the process that is due. And so our law requires particular steps that associations have to take before they can impose discipline against an owner. This law, who knows what this law is called? This in general, this group of laws. It has two persons' names. The Davis Sterling, there you go. Davis Sterling Act. This is a group of laws that have to do with nothing but community associations. Davis Sterling Act. As board members, memorize that, so you don't want anyone walking into your board meeting and saying, you don't know what the Davis Sterling Act is? Okay, so now you know what the Davis Sterling Act is. Group of laws have to do with nothing but community associations, all about community associations. The hearing letters have to have particular ingredients in them. The main thing is that they describe what's going on. It's sent out 10 days before the hearing. Doesn't mean they have to get the letter 10 days before the hearing. It has to be sent out 10 days before the hearing. It has to tell them where to show up. We do a lot of hearings now by video conference, and it's pretty effective. It's effective because it makes it a little bit more convenient for everyone, right? People are busy, so they could do it from their car. They could do it from their office. They could do it from their home. Same as the homeowners that you're going to have the hearings with. So everyone, it makes it nice and convenient. And I think it's a little bit, sometimes people are a little bit more comfortable too discussing. You know, they haven't driven 45 minutes to get there. They're not all sweaty and angry. So, and I think people are just kind of getting used to video conferences, just like it took us a while with emails and texts, so that they're kind of, you know, they're relaxed. Not saying everyone's letting down their guard, but they're just more apt to be a little bit more, to say what they mean, you know, rather than, you know, feeling kind of out of sorts by being there in person. So it's pretty good, I think. The process that's due, so they get the letter. If they attend the hearing, I'd say 80%, just get them there. 80%, you're going to get it resolved. So the odds go way up if you could get that owner to attend. Ignoring the hearing letter, not showing up, you know, it's kind of like, well, now we have to go to the next step. What if a owner doesn't attend? You still have to hold the hearing. So let's go to the hearing. My favorite part. All right, so maybe you guys know hearings pretty well. Who here has been in a disciplinary board hearing? Raise your hand. Yeah. All right, so this is basically where you're the judge, the jury, and the executioner. What could go wrong? Right? This is all your decision. If you're going to have good guidance with your manager, with AMC, I go to a lot of these too, and I run them. And so it takes the load off the board members. But so long as you stay within the lines of the law, what was that law again? Davis Sterling Act. As long as you stay within those lines, your CC&Rs, your manager, they'll guide you, or your attorney will guide you, and you have a pretty good chance of resolving it. You are able to draw out of the homeowner exactly where they're coming from. Getting a little bit of discussion going is one way. Sometimes and you have a lot of flexibility as far as your participation. I like a lot of participation with my board members, even though I'm running it. And I will tell them, speak up. The owner needs to hear from you. They want to know from you how you feel. This is your chance to give all this information. Some board members are so angry, though, by this time that it's okay, they can't talk because the violation is so personal to them. What if a board member was the one who is complaining about the violating homeowner? So the board member, they're the ones they found the violation. It might be a neighbor. They're complaining about the violator. Can they still participate in the hearing? Can they still vote on the discipline, even though they're the complainer? Let's just see a show of hands. Who says they cannot? Who says they cannot? A couple of you. It's a little confusing. They can indeed. They could be the one that tagged that owner, that brought it to the manager, that knows all the facts. And I'll have a lot of owners, and they'll say, violators, and say, well, how could this board member, they're the ones that are complaining about me. Okay, the law doesn't prohibit that. What does the law prohibit? The law prohibits if the board is having a hearing about a board member. If a board member is a violator, then the board member cannot participate in the decision. That's in the Davis-Sterling Act. That makes sense to me too. And similarly, if a board member is delinquent in assessments, they don't get to vote about collection efforts against them. If they have an architectural application, they don't get to vote about the architectural application. But just being a complainer, that the main board member who has the gripe, no problem with that. Yes, question.
Architectural submission by board members. There were only three board members at that time. And I happen to be the one board member who submitted it.
And I'll repeat this so you can.
Sorry, guys.
No, don't worry, I'll repeat it.
Until the other two had either approved or denied before I weighed in. But my understanding was three of us had to weigh in.
All right, so the example is that there were 3 board members on a 5-member board?
Yes, we only had 3 board members at the time.
Yeah, okay.
People were stepping up. Not a new problem. Yeah.
I was going to say, yeah, she said a lot of people weren't stepping up to be on the board. Lynn says, yes, not a unique problem. All right, so and you said what happened was you submitted as a board member your architectural application to the association, and then the 2 board members, they would.
I submitted it through Appfolio.
Okay, you submitted it online.
And
Okay.
Online, Appfolio sent me a notice to approve this new submission, along with the other 2 board members getting the same thing. So I
Okay.
thought, okay, this is really uncomfortable, so I'm just going to wait a week.
Yeah,
So,
yeah, good job.
and I'll ask the board members, what do you think?
Yeah.
They both said, well, we approved it. And then I went ahead and I approved it as well.
All right, no harm, no foul. Good job. You felt something wasn't right.
Yeah.
So that's good, right? You're not supposed to vote on your own application. All right, okay.
Would 2 out of 3 be a majority and it would make it okay?
That's a good question. So you have a 5-member board, you have 3 board members, and then 2 voted in favor of it. You're okay because you had a quorum of 3, and a majority of quorum is 2. So she was good. You see that?
Yeah, you
You see how that works? It works out. All right, continuing on. Oh, question, go ahead.
So Brent, what do you recommend an association do when you have two homeowners that are having a dispute about who's causing the most noise and all of that kind of thing? Do you ever bring them together in the same room?
I love it. Great, great, great. One of my favorites. All right, let's make sure we understand what's happening. This happens all the time. This is like part of my life. I'm always dealing with two homeowners, or it could be two tenants, could be a owner and a tenant. And I loved how you put it. They're having a fight over who's being the noisiest. They're probably having a contest. Who could be the noisiest? That's being facetious. No, and it's usually not like this. It's usually like this. It's right. So you got upstairs, downstairs, and my one that I got today, local association, upstairs moves in tenants, and they're just plain too noisy. They don't understand they're living in a condominium. Downstairs, she gets so mad that she's doing the old-fashioned broom on the ceiling. I don't want to see what her ceiling looks like, but I probably will have to. The twist in this one was the downstairs owner, since she was there first, this is a new tenant, the downstairs owner recruits her neighbors to harass the one upstairs. Yeah, it's getting out of hand. All right, so that is called, that has a nice little name to it. It's a neighbor-to-neighbor dispute. It's a neighbor-to-neighbor dispute. So what do we do with that neighbor-to-neighbor dispute? To a certain extent, it's not good business to spend a bunch of money on a fight between two owners. That's not affecting anyone else. That's not affecting the common area in general or other owners. If they're noisy and they're causing noise to other people, right, other neighbors, yeah, but oftentimes just between the two. And so you want to tread lightly, and you want to let everyone know, basically, that you'll try. You want to take some steps, but you probably don't want to spend a bunch of money and file a lawsuit, spend all this money when it's not your deal. Now, her specific question was, what about getting those two in the same room, right? I've done that. That can work. And it should work. It really should. You can do it by having a hearing like this, or we'll get to it in a second, but talk about it now. Has anyone heard of IDR, Internal Dispute Resolution? That's sort of what you're talking about. It's a process in place, it's about 25 years old, whereby you can get owners with board member representatives in the same room and try and work it out. There's no pressure. There's no going to be any discipline imposed. It's just let's get together and do what they call meet and confer. Meet and confer, internal dispute resolution, IDR, and yes, you can do it. So my one that I just got today, the manager says, well, we asked the downstairs owner if she would participate in IDR with the upstairs. And the downstairs said, I was told not to do this. My brother told me not to do it. Okay, so she's taking legal advice from her brother. So it's a great idea, but you got to get in the same room. It's like what I was talking about with the hearing. If you could get that owner to attend, you might be able to settle this issue. 80% chance, maybe higher. So what you want to do, some tips at the hearing. We sort of talked about most of this. But you want to basically, you sue the bus company, you still have to pay your own attorney's fees. So that's why there's contingency fee agreements and stuff like that. You know what a contingency fee agreement is? The attorney gets a percentage. Go ahead.
I want to ask, can you name 3 things that we, the board, the association can sue an owner for? Like maybe they're not, one of the things I would like to ask, like maybe they're not cleaning up around their property.
Not cleaning around the property,
Is
okay?
that something that we can sue for them breaching CCNR?
You can. So anything that the CCNRs restrict,
Right.
owners in violation of that, you could get a court order that says, owner, you must clean up around your property. Owner, you must not have excessive noise. Owner, you must pay the association's attorney's fees.
Okay.
Okay? Couple more slides. Hang in there. Don't go anywhere. You too. I'm kidding. I'm kidding. I'm kidding. All right, so the attorney's fees go way up. 10 grand, 20 grand if they litigate, if they fight it. Most cases solve at 5 grand or less. Thank you. Okay. So now we're just going to end with this slide because a lot of times when I do my presentations, board members get scared and they want to quit the board. So don't do that. Look, you guys you're not going to be liable. Don't worry, you're completely protected. In my 30 years of doing this, I don't know of any board members, hundreds, thousands of board members. No one's paid a penny. I even had a board member punch a guy at a board meeting. He didn't pay anything. All right, you have all these protections. You got your insurance. Actually, the insurance policies, insurance companies get a bad rap. All these insurance policies for the protect board members, super good. They step up. You have the civil code, that's the Davis-Sterling Act. You have the corporation code, CCNRs, comply with your fiduciary duty. That is, act reasonably, best interest of the owners. Don't make decisions unless you consult with an expert on things outside your expertise. Fiduciary duty, you're protected. Don't worry about it. Okay? We have questions now?
Yeah, we can do questions. If there's more questions, I also have some questions for you.
I have 2 questions.
Okay, Lynn?
Okay, so if we give the notice of, let's see, what is it called? Notice of violation, part of that notice of violation must include a notice of a hearing?
No. So
Okay.
you could do a courtesy notice,
Okay.
then you could do a warning notice, then you could do another notice. At some point, if you want to hold a hearing, you got to send out the notice 10 days before.
Okay, and then the other thing is, we've mentioned rules and we've mentioned CCNRs. What about bylaws? How do they relate?
Bylaws really only have to do with the procedural aspects of associations, quorums, voting, member meetings, directors, all that kind of procedural stuff. CCNRs, that's the land, the property, the rights, the restrictions, the assessments, the maintenance obligation, allocation. And then the rules fit in between. No dogs off leashes, et cetera, stuff like that. Okay?
And number 3 up there, does this require a separate vote by the board or members to move forward on defending a board member?
Yeah, but let's not get confused. Insurance will step up.
Right.
This is there where this says that if you want the association to pay to defend an owner as a board because of their board member duties, you need to get a vote of the owners or the board members. However, I've never seen that used because that pays for it.
So insurance, number 1, if you have insurance, you're good. But if you
Right.
don't, then you move down the list.
You have to have insurance. You have to have insurance. But you're right. If in fact for some reason insurance, it could happen, right? It's a gap or whatever. Then your fellow board members would have to vote.
Now, we're using the word insurance in a general way. Is this like insurance, the insurance that is covering all the buildings? Or?
Sort of. You got four kinds. You have the property insurance that covers all the buildings if they burn down, right? You have general liability, that is if someone slips and falls, so property and casualty. Right back there, farmers, right? And then he's all, Brad's got it. And then you have workers' comp, and then you have directors and officers. So we're talking about directors and officers.
Right. Directors is what?
Directors and officers, your D&O policy.
Yeah.
So Brad, I have a question for you, and this relates to rental restrictions. So a lot of associations had to amend their rental restrictions to the 25%. What are some things an association can do to ask a homeowner to verify occupancy?
Right, this is a great one. We were talking about this beforehand. I've been asked this twice in 1 week. I think what's happening is that all these rental restrictions are in place, but over the years, the board, the associations have lost track of who's renting and who isn't. And so I'm putting together sort of a list to the two clients that came to me, two associations. You have, so Tony, you have the 4041 letter that's supposed to go out about 30 days before the budget goes out, that to have owners give you this information. You can ask this information. What we're talking about, what has helped me is because board members and managers will say, well, owners are just going to lie. Absolutely, they're going to lie. So what can you do to kind of, you have to chip away at the stone. One way is I have the board send out a request for information and to say whether you're renting or not, just like you're saying, and at the bottom you put where the signature goes, I swear under the laws of the state of California, under penalty of perjury. All right? So that kind of makes it a little more serious, right? You're nodding your head.
Yes, it is. Yeah, perjury is way far off. So we have to be careful.
Thank you.
Okay.
If an owner has been an owner for some time and one of their adult children move in, are they considered a renter?
That's a good one. You have to look. So here's the question is, you have an owner, and then they move out and their adult child moves in there for whatever reason. Is that a rental? 99 times out of 100 it is. It's how it's defined in your CC&Rs. That'll tell you.
Can I ask a quick question on that?
Yeah, sure.
Because that's one of the other things we have been trying to get done in our community is having the owners who are renting identify or send the lease to AMC and who's living in their house. So I want to know, can we sue homeowners who are not giving that information to AMC?
Only,
50 of them out of 100.
so owners aren't sending in their leases when they're required to do so?
Right.
What's requiring them to do so?
The CC&R.
CC&R say to do so?
That's right.
Then ultimately you could sue them. You'll never have to get to that point. But it's like what we did today. That's still a violation of CC&R. So you could call them to a hearing. No one wants to be called to a hearing when all they have to do is send in their silly lease.
I thought the state of California had said rental restrictions were not allowed anymore. Did I misread that somewhere?
You did. So what's it's like at 4740, 4739. There's 3 statutes in the Davis-Sterling Act, and what they have done is they've chipped away at the rights of owners, associations to restrict rentals. But like Tony said, you could have a 25% only. That is only 25% or less of the homes may be rented. They have to be voted on in the CC&Rs. They have to be a CC&R amendment. So it's kind of, it could be hard. You know, I say it's hard, but all associations eventually get it done. I don't think we've seen one association not get a rental restriction passed.
We haven't gotten it done, so my next question is.
There you go, there's an
Do
example.
we have to have the members in the association vote?
You do,
We have.
You do.
We have not gotten that. they don't want to turn it in because they want to be able to rent their house out.
That's right.
Can I offer though a caveat to that? And again, as a realtor, when you have too many renters in a community, lenders will not put a mortgage on it. And so that's what you tell your homeowners, is say, if you don't put a cap on this, you're gonna wanna sell your unit one day and you're not going to be able to unless it's a cash deal.
There you go. Plus, plus, they will be ostracized. They're grandfathered. They don't have to, if you own, and then you have the restriction, those who own, they don't have to comply until they sell it. Ostracized, that's good.
Okay. Any additional questions? All right. Well, thank you, Brad.
Thank you, guys. Thank you, everyone.